Hello, everyone. It is my great honor to welcome everyone from across the world to this event. I suppose one of the positives to come from this global pandemic is that virtual events like this are now possible. It was possible, but we realize now that it's possible. Welcome to our Canadian, Australian, and New Zealand colleagues and delegates who have all joined us here today to talk about a human rights issue that is paramount to all our countries. From Australia, I'm pleased to welcome June Oscar, Aboriginal and Torres Strait Islander Social Justice Commissioner. And also from Australia, my distinguished co-host for today's event, Ms. Rosalind Kroschner, President of the Australian Human Rights Commission. From New Zealand, please join me in welcoming Judge Sarah Reeve, who is the Presiding Officer of the Mawaniini Inquiry, and also our moderator for today, Commissioner So Noah Mali, who is the New Zealand's Equal Employment Opportunities Commissioner. Finally, from Canada, it is a great pleasure to welcome Kayak Robinson, former Commissioner of Canada's National Inquiry into Missing and Murdered Indigenous Women and Girls. Our conversation today comes at an important time. The courageous work and brave testimonies of each of our national inquiries has never been more imperative. So I thank you all for being here to shed light, to generate questions, to learn, and to share your expertise. Before I go further, I would like to begin by saying that I identify as a white woman from Quebec, Canada, and that I come from a settler's perspective to this discussion today. I will also like to clarify that when we refer to Indigenous women and girls, we of course are including those individuals who identify as 2SLGBTQIA. And finally, I would like to acknowledge that the land from which I'm speaking today is the traditional and unceded territory of the Algonquin Anishinaabe Nation, and the land and the waters of what is known as Ottawa, Canada. And since we are meeting virtually, I would also like to honor all the various Indigenous territories represented today. I acknowledge that traditional owners of country throughout Australia and their continuing connection to land, sea, and community. We pay our respects to them, their cultures, and their elders, past, present, and emerging. I acknowledge the traditional lands of the Indigenous people of Woteora, the Treaty of Waitangi, and the elders past, present, and future of the land and country we know as New Zealand. These land acknowledgements are much more than a formality. They are an essential part of any meaningful gathering. And they are an essential part as a larger effort towards reconciliation and understanding our collective past, present, and future, which is what today is all about. The oppression faced by Indigenous women and girls is as much about our national histories as it is about our present and our future. The roots of these human rights crisis go all the way back to colonialism. It started then and it continues today. The denial of the human rights of Indigenous women and girls is the direct result of an entire system, a system founded on racism, a system that was built brick by brick by colonial settlers. They set out to systematically eradicate indigenous culture, steal indigenous land, and disregard the inherent worth and humanity of indigenous peoples. Here in Canada, at the center of this destruction was the residential school system. The residential school system are Canada's shame. In recent days, we have come face to face with this shame once again with the gruesome discovery of several unmarked graves at residential school sites. Most of them are the graves of young children who were stolen from their homes and their communities and sent to these schools where many died of various forms of neglect and abuse. Of course, Indigenous girls were taken to the school as well. If they survived, it was often with great trauma. Today, as everyone here knows all too well, there is a short, clear line between the denial of human rights of Indigenous women and girls and the roots of colonialism and colonial racism. Addressing this urgent issue is going to require systemic, holistic solutions. That is why in 2019, following the release of the final report of the National Inquiry into Missing and Murdered Indigenous Women and Girls, the Canadian Human Rights Commission immediately endorsed the 231 call for justice. It is why we commended the inquiry for taking a broad human rights-based and Indigenous rights-based approach that considered the root cause of the violence. As a result, inquiries calls for justice span a whole range of determinants and contributing factors, from barriers to healthcare and education to denial of culture and the right to self-determination. These kinds of issues and problems do not grow in isolation. They feed one another. That's what we mean when we say a human rights-based approach, an Indigenous rights-based approach. We mean to see the whole person, including the broader history they were born into, and the entire community and society that surrounds them. And with that, it is now my great pleasure to hand the microphone to our moderator for today, Commissioner Sono Mali. Thank you. Thank you, Commissioner.
Merci, Chief Commissioner Landry, and thank you for the acknowledgement of the harm and the damage and the harm that many still live with and are yet to receive restoration for. So thank you very much for your acknowledgement. Tēnā koutou katoa, malo le soifua, malo le langi mama, tau paia mamalu o le au le o iai au paia mamalu e mai le vavau e o le whavavau. I acknowledge the sacredness and the inherent dignity and honor of all our Indigenous peoples and our sisters who are gathered here, and all our tribes and our genealogies. That inherent honor and dignity has existed before time and shall exist forever. Before we go further, I would like us to observe a minute's silence for the victims, as Chief Commissioner Landy has spoken of. And let's have in our thoughts the children and the families and the peoples and native peoples of Canada who are suffering. And we pray that restoration and justice will be ensured through our work and the work of the Canadian peoples. So let's start our minute of silence. Thank you. Thank you, everyone. It is now my honor to introduce Commissioner June Oscar. June is a proud Bunuba woman from the remote town of Fitzroy Crossing in Western Australia, Kimberley region. She's led a successful community-driven campaign for alcohol restrictions in Fitzroy Crossing and is an international advocate on the impacts of trauma and fetal alcohol syndrome disorder. Today, Commissioner June will speak about, excuse my if I get this wrong, Commissioner, Wiyi Yani U Tangai, or Women's Voices Report, which is the first of its kind since 1986 and focuses on the rights and aspirations of First Nations women across Australia. Over to you, Commissioner Oscar.
Thank you, Sana O'Malley. Thank you very much. And Jalonguru Maningare, Jalonguru Langu, Jalonguru Maningare, Maninga, Wiyane, Winyungara Jitanga Ngaragananga Moy, Ngaragananga Ngaranye, Ngaragananga Mimi, Ngandaja Punova, Ngaragatangane, Lingawara, Yaranga, Karnyangare, Jugo, Mimi, Ngawiki, Ngaranyi, Marne, Palangara, Yanangara, we, Ngagio Amoy, Ngaragio Amoy. I speak to you in my language, Bonoba, and I say, let us remember, especially at this gathering, all our first mothers, our great grandmothers, our sisters, our daughters, our matrilineal lineage of the first women that turned the soils on each of our countries. Let us always remember them because they sustained our societies to ensure that we can be here today and continue to remember and continue to fight for justice and equality for all our peoples. I speak to you from in the Kimberley region on Bunuba country, the lands of my people, and I pay my respects to them, and I pay my respects to your elders, past and those present who are keeping families and communities and clans together, and those who are emerging from among us. I thank you all for being in this shared space and joining with us from all of your lands. And thank you, Chief Commissioner Landry and Commissioner Sana O'Malley, for the lovely introduction. My name is June Oscar. I'm Nyanjili, and I am the Aboriginal and Torres Strait Islander Social Justice Commissioner at the Australian Human Rights Commission. And I acknowledge the President of the Australian Human Rights Commission, my colleague, Ms. Rosalind Croucher. I am the first Aboriginal woman to hold this position in 25 years, I think. Anyway, I hope that that has started a process to see more of our women come to these positions and share their leadership with the world. So I'm really excited to be here, but I'm feeling for you that it is early in the morning or late in the evening for some of you. And it's probably been a big day, a big week, big month, and it's certainly been a big year. And I'm honored to be sharing the stage with both Commissioner Robinson and Judge Reeves to talk about the rights of First Nations women in our respective countries and to talk about Wiyaniu Dangani, meaning women's voices in my Bunuba language. And so you got it right there, Sana O'Malley. Very good for first time. So the report and the report calls for gender justice and equality for First Nations women in Australia. So I want to state at the outset that I feel we are at a very significant point in global history where moments of reckoning around racism and misogyny are happening in nations everywhere. COVID-19 has exposed deep inequalities that disproportionately impact those of us who have been marginalized and treated as insignificant minority groups. I believe more of us than ever have had enough of the historic and current systems that produce these inequalities. And although we are talking about some of the severe consequences of those systems on First Nations women and girls today, I feel that at the same time as exposing these legacies of injustices, we also experience a resurgence of First Nations women's knowledges, of our power and our self-determination. First Nations women in New Zealand, Canada, and Australia are, in my view, reclaiming our place and space to be making decisions about our lives, to reconstruct and restore our healthy societies for generations to come on our terms. This is a key focus of We Yanyuwa Dangani report, and We Yanyuwa Dangani was tabled in the Federal Parliament on the 9th of December last year, 2020, and features our women and girls' voices on every page. We visited over 50 locations and had conversations with over 2,000 women and girls face to face, who generously gave us their time and shared their stories. These engagements generated a once-in-a-generation whole-of-life report that represents the collective voices and lived experiences of First Nations women and girls across Australia. The report itself spans several chapters with 5 thematic sections and provides a much-needed gender lens to a range of issues, from justice, health, social and emotional well-being, housing, family violence, trauma, employment pathways, economic participation, disability, and service delivery, amongst many others. And what it clearly highlights is that First Nations women experience gender inequality in a very specific colonial context. Our experience of gender inequality goes beyond the different values afforded to men and women. It is also the unequal value and distribution of power afforded to Western voices, knowledge, and institutions over the knowledges of First Nations women and society since colonisation. We Yanyuwa Dangani, its recommendations and its pathways forward were formed so that we as a nation could think about how to adequately respond to the needs identified by First Nations women and girls through a gender-specific lens informed by their voices. What arose from the report's findings is 7 overarching structural reform recommendations and a series of pathways forward that set a determined agenda to change our current systems from those that are punitive to those that are preventative, healing orientated, and enabling. The recommendations call for large-scale structural change. or the kind of systems change that is needed to combat and overcome the inequalities and the intergenerational harms and trauma that First Nations women and girls experience. Now the report is released. Its recommendations need to be implemented. This is the work of stage 2, the work we are currently undertaking. This year we have been working with women and girls and other stakeholders to socialise the report, provide support to women who are pushing forward with implementation in their communities, and bringing stakeholders together to develop the building blocks for a coordinated national process to implement the report. So the next phase of the report is the establishment of a First Nations women and girls advisory body, running a national summit in 2022, and from that, beginning the process for developing a First Nations women and girls national action plan. There has never been one in Australia for First Nations women. I see a national summit as pivotal to ensuring that the work we have done to date can culminate in strategic dialogues where our women, key partners, stakeholders, and governments can really consider our women's and girls' place in the social and economic recovery post-COVID-19. It would result in an action plan to seriously advance gender equality for First Nations women and girls in this nation. It would also support all actors across various systems and sectors alongside of policymakers to understand how to implement First Nations gender justice and equality in the development of policy and work practices throughout Australia. The successful implementation of Wiyaniyu Dangani is dependent on governments and other stakeholders entering into genuine dialogue and partnership with First Nations people. Actions across every sector and the structural changes to support these actions need to be identified and progressed so implementation of the report is effective. So Wiyaniyu Dangani and its recommendations are grounded in a strength-based human rights approach. The importance of projects like these cannot be understated. The causes of ongoing disadvantage are structural, not individual. And that is why systems must be pursued. Wiyaniyu Dangani is looking to establish an action plan to drive structural change that can be looked to internationally to make human rights applicable and meaningful to First Nations women and girls across the globe. This is long-term work. By advancing First Nations gender justice and equality as a cross-cutting priority, we are trusting First Nations women and girls in their knowledge and intentions, and we are providing alternative and innovative pathways that allows them to stand fully in their agency to bring about the outcomes they deserve. So thank you for your time today, my sisters, and thank you for your support.
Thank you very much, Commissioner Oscar. We'll probably be able to come back in question time for you to be able to elaborate further on some of the issues that you raised. But thank you very, very much for that succinct representation of what sounds like a huge, huge piece of work. So thank you very much, Commissioner. It's now my honor to introduce our second speaker, Commissioner Kwajak Robinson. Hope I got that right or close to, who joins us from the Canadian Human Rights Commission, born in Iqaluit and raised in Igloolik. She is a strong Northern advocate who is fluent in Inuktitut and English and is a graduate of the Akit-Sirak Law Program. Commissioner Robinson, please feel free to tell me off when you start with my pronunciation. But Commissioner Robinson was a commissioner for the National Inquiry into Missing and Murdered Indigenous Women and Girls between 2017 and 2019, and will speak to us today about the Reclaiming Power and Place, the final report of the National Inquiry into Missing and Murdered Indigenous Women and Girls. Welcome, Commissioner. The floor is yours.
Thank you. Your pronunciations were quite good. Inuktitut is quite a difficult language. My name is pronounced Kaya Robinson. The Robinson generally doesn't create much problems, but my name is Kaya. I am named after the late Laszlo Kaya of Mitimatalik Pond in the Nunavut. Thank you so much for the introduction, and thank you for particularly Commissioner Landry for the invitation to participate in this discussion today. I want to first sort of situate my voice. I was one of the 4 commissioners under the leadership of Chief Commissioner Buller and alongside Commissioners Ailson and Odette as one of the commissioners on the Canada's National Inquiry into Murdered and Missing Indigenous Women and Girls. Although I was given the tremendous honor being born and raised in Northern Canada in the Nunavut territory, in Inuit Nunangat, among Inuit, and given the gift of knowing their language, I am a non-Indigenous woman. My parents' ancestry are settlers, and I think it's very important to be clear about who I am and how I enter into this conversation. I am joining you as the sun is rising in unceded Algonquin territory near the nation's capital in Canada, what is now known as Canada. I want to start by acknowledging all the families who've lost loved ones to violence, the families of the murdered and missing Indigenous women and girls, as well as survivors of violence. I'm always in awe of families and survivors that come forward and share their truths and their testimonies, particularly because in sharing, there is no turning back the clock. There is no bringing back their loved ones. And I'm always reminded that when families and survivors come forward and share their lived experience, their passion, the atrocities they've experienced, they do it for us. They do it for us as a collective, and for our collective future. And I always think it's important to reflect on those gifts and the teachings that we are provided by those that know this more than anybody else. In my 10 minutes, I'm going to talk a little bit about the National Inquiry, our structure, our report, how we undertook our work, and some of the understandings that the findings, as well as calls for justice that we came to. The Canada's National Inquiry into Murdered and Missing Indigenous Women and Girls was launched in 2016. It was the first truly national inquiry We had orders and councils from all of the 14 jurisdictions, the federal government, the 3 territorial governments, as well as all of the provinces. This was unique, but incredibly necessary for us to be able to do the work. It was known that the various issues that would arise were rooted in the child welfare system, the healthcare system, justice systems, education, you name it. And having merely a federally mandated inquiry would have been insufficient for us to be able to look at all the systems and structures and institutions at play. We released our report on June 3rd of 2019, and included in our report were 2 volumes, which included over 250 calls for justice, as well as a supplementary report explaining our finding and conclusions in relation to genocide and the legal analysis around that. In terms of what we were asked to do, although the title of the National Inquiry was in relation to murdered and missing Indigenous women and girls, our mandate was much broader than the murders and the disappearances. We were called on to inquire and report on the systemic causes of all forms of violence. This was a bit, the title of the inquiry was a bit of a misnomer, and it was a bit challenging to bring the country along in understanding that this was more than situational or individual acts of violence or disappearances and murder, and it was more about the systemic causes, whether it was economic, social, institutional, historical causes and contributors to violence. We were also asked to examine different institutional policies and practices and discover what has been working and what has been effective. Finally, we were asked to provide the 14 governments, federal, provincial, territorial, with concrete actions and effective solutions to help remove and address those systemic causes and to increase safety in general. Finally, the mandate and the hopes of the inquiry from the perspective of those governments that mandated us was to promote healing and reconciliation and to promote ways of honoring and commemorating those lost to violence. There were a number of limitations and challenges that I think is important to share with you. Primarily, as indicated, this was a systemic analysis inquest. We were prohibited from making conclusions regarding civil or criminal liability. Further, we had to be very careful so as to not to jeopardize any ongoing criminal proceedings or investigations. This was something quite challenging as many of those who fought for inquiry for many, many years had different visions and hopes of what an inquiry could be. Many sought justice on an individual level for their specific experiences, for the violence they experienced, and particularly for the loss of their loved ones to violence. That wasn't something that we could provide. What we hoped to do in our work was to gather the truths, the testimonies of families and survivors, grassroots folks, and frontline workers, and those doing the work within their communities to create safety and security and justice within their communities, and to learn from them about what violence in Canada looks like, and more specifically, feels like, and from them to learn what the solutions were. It was really about weaving together, and I often think about it like beadwork, or a painting or a quilt, where the testimonies of the families and survivors and all those that came forward and shared with us contributed a piece to that beadwork. And in the end, when you step back, we were able to see this is Canada for Indigenous women and girls and gender diverse people. I'm going to pause on that. In Canada, in the Canadian context, when I speak of Indigenous women and girls, I speak of the First Peoples of this land, and those are First Nations, Inuit, and Métis. And within those constitutionally recognized peoples, there are also numerous nations and peoples and languages. I often feel like, you know, using language of just Indigenous is this creating a homogeny that doesn't exist. There's incredible diversity within the Indigenous peoples of this land, Inuit, Métis, First Nations. And when I say women and girls, I also include gender diverse peoples, Two-Spirit, 2S LGBTQIA+ people. This was something that was very important when we were doing our work to understand indigeneity in these lands in its most fulsome sense, and to understand Indigenous women and girls in its most fulsome sense. Recognizing that for many Indigenous women and girls and gender diverse folks, their identity and their status as Indigenous was removed from them, was denied them, and that this was part of the colonial violence that they were subjected to. So by taking state recognized understandings of indigeneity would in effect be a perpetuation of the violence of denying indigeneity. So we took a very broad and inclusive approach in understanding indigeneity in Canada, as well as Indigenous women and girls, recognizing that for many Indigenous nations, the understanding of gender isn't within a binary. So we had to, we were very focused again on it being inclusive and being as broad as possible when looking at who this inquiry was for. I think another thing that was very important and was very foundational to our understanding of the work we were doing, and what was something that was often a bit of a challenge, particularly when communicating with the broader Canadian public, who quite comfortably were willing to see this as being, you know, this is for Indigenous peoples. This is about Indigenous peoples and Indigenous women and girls. But that is not the case. And it's very important, I think, and something that I wish to reiterate and will reiterate as long as I have a voice to speak, that this was not a study of Indigenous women and girls. This was an examination of Canadian society, Canadian institutions, and the state through the lived experience and the expertise and the agency of Indigenous women and girls. There's nothing inherent in an Indigenous woman and girl that brings this violence on. It originates in this state, in this land, and how we have structured this state. And what we needed to do, what we needed to elevate was the voices of those living under the state. So that is something that I think is a very important thing, that what we did in Canada's National Inquiry into Murdered and Missing Indigenous Women was learn about Canada from the perspective of Indigenous women and girls, their lived experience and their expertise. And we did so on examining and coming to understand and measuring Canada up against human rights, domestic and international, through the lived experience of Indigenous women and girls. In effect, really measuring the Canadian state against its own laws and values, which I think was an important approach to take. I quite frankly think it was the only approach to take. We thought it was
Commissioner-
very, sorry.
Sorry, Commissioner, I'm just wondering if we could just have a couple minutes and then we'll
Yes, absolutely. I'm going to
expand
just
into the
go
questions.
into our fundamental finding, which was that the root
Yes, go
causes
ahead.
of the violence, the root causes of the violence in Canada originate to colonialism and colonization. The colonization is a violent act. And the violence of colonization, historic and ongoing, is being experienced today, and the disruption that it has caused is the root causes of the violence that is being experienced today and in an ongoing way. I'm going to read the first of our findings, which I think is the most significant and overarching, and that is specifically that the significant, persistent, and deliberate pattern of systemic racial and gendered human rights and Indigenous rights violations and abuses perpetuated historically and maintained today by the Canadian state, which was designed to displace Indigenous peoples from their lands, social structures, governance, and to eradicate their existence as nations, communities, families, and individuals is the root cause of the disappearance, murders, and violence experienced by Indigenous women, girls, and 2S LGBTQIA+ people. It was intentional, it was deliberate, it was designed to assimilate and eliminate. And we understand this to have been numerous acts of genocide. And that was our overarching finding, and our calls for justice speak to how we recover, what the remedies are, and we look at them as legal imperatives because they are rooted. The calls for justice are rooted in domestic and international human rights instruments, as well as instruments that recognize Indigenous rights. I will leave it at that, and hopefully we can discuss a little bit more in the question and answer. Thank you, Nakomic.
Thank you very much, Commissioner Robinson. We don't say the word genocide lightly, so I'm sure it'll come up in the question. So thank you very much. So our third panel speaker now, Tēnā koe rangatira, Judge Sarah Reeves was appointed to the Māori Land Court on the 10th of September 2010. She's based in Wellington and is a resident judge for the Te Waipounamu district of the Māori Land Court, hearing cases in Nelson, Blenheim, Christchurch, Dunedin, Invercargill, and the Chatham Islands. So for people not familiar with New Zealand, it's basically the South Island of New Zealand plus the Chatham Islands. Judge Reeves is currently the presiding officer of the Mana Wahine inquiry and will speak to Aotearoa New Zealand's recently launched Y2700 Wahine Kaupapa inquiry, which is intended to provide a pathway to hear issues of discrimination by the Crown that affects Wahine Māori. The floor is yours, Judge. You're on mute, Judge.
Tēnā koutou katoa. Nā mihi kia koutou ko tai mai I tēnei hui. Ko toko maru te waka, ko taranaki te maunga, ko te ati awa te iwi, ko Sarah Reeves taku ingoa. As is mentioned, I'm Judge Sarah Reeves, presiding officer for the Mana Wahine inquiry, which has recently started. That's the Māori Women's Thematic claim in the Waitangi Tribunal. I'm a Māori wahine, Māori woman, and I have just located myself by reference to my canoe or waka that my ancestors voyaged on from the Pacific to Aotearoa, my mountain and my tribe. I am on a language journey as are many women, Māori women of my age. I'm in to recover our Indigenous language. So I have some slides. I'm a chronic over preparer, so I have prepared some slides and which will take us through, I guess, some of the main points that I want to make about the inquiry. So if we could just move to the first slide. The foundation of the, first I should say, all judges of the Māori Land Court, and there are about 14 of us, we are all also presiding officers of the Waitangi Tribunal. If we could have the second slide, the one which is headed Waitangi Tribunal. Is that for me? So the founding document is the Treaty of Waitangi, signed in 1840 between the British Crown and Māori tribes and sub-tribes. This is the document which, in a sense, some would say is the founding document of the country we now know as New Zealand. Approximately 500 chiefs signed that document as it travelled through the country during the course of 1840. We understand that approximately 13 women chiefs signed that document, and that we know of. There may have been others, but they haven't been identified as yet. There are 3 articles of that treaty. The first article in the English text cedes sovereignty, while the Māori version only grants the right of governance to the British Crown. The second article in the English text grants protections of villages, estates, and other real properties, while the Māori text grants the right for Māori to retain authority over those matters. And the final article of the treaty grants rights and privileges of British subjects, while the Māori text assures Māori that they will be treated equally to British citizens. So the Waitangi Tribunal, of which this inquiry is located, was established by legislation in 1985. We hear claims that are brought by individuals on behalf of groups, and we have 4 categories of inquiries. We have district historical inquiries, and that program, which started in the 1980s, is now nearly complete. The tribunal has inquired into more than nearly 90% of New Zealand's land surface, has issued reports, and many of those reports have provided the basis for the treaty settlements which have been concluded between the Crown and iwi. So we are now moving into an inquiry program which we call the Kaupapa inquiry program, and those are the broadly based thematic inquiries. These are inquiries which, rather than being based in relation to the grievances or allegations of particular iwi or tribes, these are issues which are of significance to a significant proportion of Māori. So here we have up on the slide the current kaupapa thematic inquiries that we have running in the Waitangi Tribunal at the present time. So the water inquiry, the Māori military veterans, that one proceeded because many of the veterans who fought in Korean conflicts, Vietnam, were starting to pass away. So that one was prioritised. These other inquiries are also in train. The Manawahine inquiry, the original claim was filed in 1993, and we've, because we prioritise the district historical inquiries, this inquiry was commenced earlier this year. We started sittings in February. I anticipate that we'll probably be in train for, I would say, a minimum of 3 to 4 years before we would be issuing a report, and I will talk a little bit about the process that we are undertaking. So if I could move to the next slide, the claims which have been made in the Manawahine inquiry relate mainly to the status and treatment of Wahine Māori in both historical and modern times. So they're both historical allegations from 1840, which is the date of the signing of the treaty, right up to contemporary times. So these claims broadly allege that the Crown has failed to protect the authority of Māori women, their right to non-discrimination on grounds of gender, and of course there will be allegations of serious prejudice in terms of social, economic, cultural and spiritual well-being. And the access to leadership was one of the key drivers to the original claim. So most of these claims, as I've said, have been made by individuals on behalf of whānau, those are families, hapu, sub-tribes and iwi. And we're looking at the failure of the Crown to protect the traditional authority of Māori women in relation to customary law in respect of a whole range of human endeavour and activity in environment, property, social organisation, political and institutional leadership. So the claims also will be examining specific Crown policies, acts and omissions, which are alleged to have affected and diminished the treaty-based rights of Māori women as citizens. So we move to the next slide. So examples of specific claims which have been made. We have, for instance, a specific claim being made by the Māori Women's Refuge, which is alleging inadequate state resourcing and support for refuges that support specifically serve Māori women. So another claim is the original founding claim filed in 1993. It's called the National Māori Women's Claim. It was filed on behalf of the Māori Women's Welfare League and alleges that Māori women individually as tribal members, family members and leaders have been systematically deprived of spiritual, cultural, social and economic well-being by the Crown and in a breach of those articles of the treaty. So, so maybe I'll talk a little bit about the process that we have undertaken. So the panel was constituted, the inquiry was commenced in 2018. My panel was appointed in 2019. I have a panel of 4 lay members and myself. Of our panel of 5, 4 of us are Māori. 4 of us are Māori, and 3 of us are Māori women. The panel comprises a historian member, Robin Anderson, Kim Ngārimu, Dr. Ruakiri Hond, who is a Te Reo Māori exponent, and last year we had Dr. Tuhiwa Linda Smith, who will be well known to many people, was also appointed to the panel. So we had a period of engagement with the claimants prior to the commencement of hearings, where we had a collaborative process to design how we would proceed in this inquiry. And so the range of possibilities were to perhaps look to prioritise some particular claims, which had maybe some specific urgency. For instance, in New Zealand, we have been dealing with issues around a government organisation called Oranga Tamariki, which is the care and protection of children. And there has been great concern about the way the authorities have targeted Māori tamariki in their whānau in terms of uplifts. So there was some thought that maybe we should prioritise some of those sorts of issues. But at the end of the day, what the claimants told us was that they wanted us to proceed in a chronological and thematic way. So they didn't want to say what's in the past and let's focus on what's in the here and now. They wanted us to thoroughly hear those claims and those allegations in relation to as far back as 1840. So what we have done is that we're staging our inquiry. So at the present time, we're in stage 1. And these are what we call tuapapa hearings, or they are a contextual hearing, where we are hearing what we call kōrero tuku iho. So it's traditional kōrero. Now, we are a permanent commission of inquiry. We have the Crown in the room, but for these contextual hearings, the Crown is there, but they are listening. They're not testing any of the kōrero that we are hearing. So we have women, their families, their tribal supporters coming, and they are giving us evidence, I guess for want of a better term, about conceptual frameworks about the inherent mana, or I guess prestige, and iho, that's the essence of ngā wahine Māori. So we're talking about cosmogony, we're talking about Māori goddesses, we're talking about religious spiritual beliefs, we're talking about customs. We're trying to imagine or reconstruct what were the lives of Māori women pre-colonisation. And this is going to be forming a foundation, a conceptual framework upon which we're going to measure the Crown's, the allegations of the breaches of the Treaty of the Crown. So we're establishing our conceptual historical framework, and then stage 2 of the hearings we will deal with the specific allegations that have been made and the various claims that have been brought, and those who are making those claims will bring their evidence, they will give their evidence in support of their allegations. The Crown will then have an opportunity to test that evidence, and as a result of that process, the tribunal will, at the end of the day, make findings, determine whether or not what the prejudice is, and then we will make recommendations. Now, our jurisdiction in the Waitangi Tribunal is recommendatory, so we make non-binding recommendations to the Crown. My feeling is with the present environment that we have in Aotearoa New Zealand, we have a government where we have a sizable cohort of Māori MPs who are in the Labour government of Jacinda Ardern. I think it's a good time to be proceeding with this inquiry now. I think in terms of maybe potential receptiveness of the Crown to recommendations that we might make. Now, in terms of outcomes from our inquiry, we will be, after the foundational hearings are finished, there is a research program which is going to launch. We have formed a joint research committee where we have all parties to the inquiry sitting around the table. We have the claimants, we have the tribunal, we have the Crown. And we're hoping it's going to be a collaborative process where the research program will be agreed between those parties. And one of the reports that will be commissioned is a report about remedies. And I intend, well, I certainly hope that further down the track that we will actually hold a hearing about remedies, and to really get the kōrero and the talk about what potential remedies might be in this inquiry. So we're
Judge?
very, yep,
If you can.
time's up. Okay. Yeah,
And
no,
finish your point.
I'm pretty much there. I think just really to say that the I've indicated what the Te Whapapa hearings are, but for the inquiry as a whole, we have 4 themes, 4 overarching themes for the inquiry as a whole. Those are rangatiratanga, that's the power and authority of Māori women. We have whenua, that's land. We have whakapapa and whānau, that's intergenerational well-being and covers health, education, and housing. And we have whairawa, which is economic status and enterprise. So as you can see, it's a wide-ranging claim. You know, we're not under time constraints. I think that we will be in this process for, certainly we're in the foundational hearings for the whole of this year. Then I hope to get into the substantive hearings at some point next year. We might be in those hearings for a year, perhaps 2 years, and then maybe a year to write a report. So our claimants have been waiting since 1993 for this process. So they're really not in a hurry. They want us to do a good job of it. We're in hearing this week in Whangarei. So we've had some fabulous evidence, and you know, I have high hopes that we're going to end up at the end of the day with a really substantive and important report. So thank you, everybody. Kia ora tātou, and I'm happy to take questions when the time comes.
Great. Kia ora, Judge. Thank you very, very much for that. I'm just keeping an eye on time, and we do have some questions, but already here. But I'm wondering, just looking at our participants who are bursting with questions, and I wonder if I could start with Commissioner Oscar. There's a question here from the floor. Can you comment on the role of higher education for Aboriginal women in the vision for equitable citizenship?
Wow. Just a moment. I think our women, whilst we have many, many challenges, and women carry such huge responsibilities for family and community, and not just for themselves. We were able to have some wonderful conversations with the women and girls we met with, and we really did celebrate their achievements. Women were able to share with us not just the concerns that they have, not just the matters that undermines women's rights to achieve and to succeed, but to celebrate the fact that we are witnessing more women, young women graduate from secondary education, more women entering tertiary education and achieving in areas of medicine, of law, and many other critical professional spaces. So whilst the Women's Business Report of 1986 was very limited in what it had to say about the achievement of Aboriginal and Torres Strait Islander women, back then when I was a much younger woman, we've reached a point in the history of our journey in our country where we're celebrating so much that women are achieving.
Thank you very much, Commissioner Oscar, for that response to that question. There's a question here for Commissioner Robinson. May I ask if your findings have been shared and implemented with the community involved in the projects? And then, have the missing women and girls been found? So that's
A couple of questions within that question.
Yeah, yes.
In terms of sharing of the report, it is accessible online. There have been some printed versions, some on my bookshelf there, but it hasn't been widely distributed, and this would be one of the critiques I have for critiques and reflections I have on what really needs to be done next. We were unfortunately a temporary, we had time limits. So the part of the work that we did, the part of any inquiry, which is really foundational when it comes to broader systemic inquests, is that you need to bring the country along with you and ensure that it is a society-wide learning experience, particularly if part of the objective is reconciliation, which is something that the Canadian Prime Minister and the current government and other governments has emphasized as really a priority. But if you're going to do that and you're going to have an inquest like ours that is vast in duration, we covered like 150 years. There was no end date, start date, and something that's ongoing. It needed to have a continued life after our terms were done, particularly to ensure that the broader Canadian public learns the content. I really see what those that shared with us did was correct the narrative of what the history of this country is and what the current reality is. So yes, it is something that's available. It is something that is out there, but it was a moment in time that it was shared, and there isn't that ongoing dissemination of information. With respect to the specific murders and disappearances, we weren't able to resolve any of those. We did have the authority, if we received information or that we thought could advance the investigation or that spoke to potential misconduct by officials, we had an obligation to give notice to different institutions of what we found. And I do know that, and we issued, I think, close to 200 of those to prompt institutions, whether it's policing institutions or oversight bodies that deal with the conduct of state actors. What happened with those, I don't know. Some investigations have received some new attention following the inquiry, but it's hard for me to say, as our ability to access information and to get an idea of what's happening ended on June 30th of 2019 at midnight. We were working right up until midnight. So I can't really answer that last question. Many cases remain unresolved and families are continuing to fight for answers and justice.
Thank you very much, Commissioner Robinson. We have a question to Judge Reeves. I know when the beginning phase of the inquiry. But have some of the claimants specified their expectations of what they expect their ideal of a response should be from government? Any sort of things specific at this point from the hearings that have already happened?
Nothing really too specific at this point.
Right.
We really are in a very early stage, and we're going to have some quite there will be steps within the inquiry process that are going to deal with possible potential remedies. We're going to be looking at doing some research into that, and also to have specific hearings around remedies, in which claimants will be invited to come and to give their ideas, and for us to discuss that within the course of the inquiry.
All right, thank you very much, Commissioner. Can I just squeeze in a quick question to Minister June Oscar? There's a quick question about, you talked about the national body, Aboriginal women, they're looking at setting up. So someone has asked, what is the process for nominating people to be part of that First Nations Women and Girls Advisory Body? Is there a process you can talk about?
No, well, we haven't quite reached that point at this point in time. We've been focused on presenting that as one of our areas covered in the recommendations, and so we haven't. That's part of the mechanics, the details of it all, and we're not quite at that point yet.
Okay, great. So hope you heard that, Siobhan, the person who asked the question. And I've got this question for all of you, for all of our three panelists. How are each of your nations working towards the implementation of the Declaration of the Rights of Indigenous Peoples? And then how can we work together, our bodies work together to hold our own government to account, as well as perhaps collaborate to hold each other's governments to account? So I wonder if I could go to Commissioner Robinson to start off your thoughts on that question.
So in Canada, one of our calls for justice was the implementation domestically of the UN Declaration on the Rights of Indigenous Peoples. And in Canada, at the federal level, there is legislation that currently passed recognizing the declaration domestically, and there's also been in one of the provinces. I think that one of the issues that we have here in Canada is really remedy and recourse and ways of ensuring compliance and upholding and respecting of the rights of Indigenous peoples, specifically women, girls, and gender diverse peoples. There is tremendous distrust of the existing legal systems, understandably, and this is why we called for the establishment of an Indigenous Rights Commission and a tribunal commissioner and tribunal commissioners and tribunal or an ombudsperson, a space where recourse and remedy can be sought. I think that, legislation and even these reports, until there is action, they are literally just pieces of paper. So there needs to be that work done. I think that in addition to ensuring that we have these remedy and recourse bodies that are co-built with Indigenous peoples. I think that's an important element of it. But we also need to be doing the work of understanding what living one's rights looks like, right? You can have a government that states that they uphold and recognize rights, but if individual Inuit, First Nations, Métis women and girls and gender diverse peoples don't live their rights, don't exercise their rights, it's rather meaningless. And if we can't measure that, so there's a lot of work that needs to be done in terms of I guess measuring success and measuring implementation. Those are, I think, some really key areas. I think that we as non-Indigenous Canadians as well play a really important role in holding our governments accountable. In Canada, we are the majority, so we need to be pushing. This has to be something that, you know, former Senator Sinclair often says, you know, we are all treaty people, we all have a responsibility. And I think that that is fundamental when it comes to holding governments accountable for the recognition, respecting and upholding Indigenous people's rights. And it's something that we have an incredible responsibility in doing that, as we are, whether we are active in it or not, or complacent at minimum, the oppressors. So it's the work that we have to be doing as non-Indigenous peoples.
Yeah, agree. Thank you, Commissioner Robinson. Commissioner Oscar, would you like to respond to that question?
Yes, thank you very much. Very important question. The appetite here to respond in a genuine and holistic way, and the way the UN Declaration on the Rights of Indigenous Peoples needs to be responded to by national government and jurisdictions, has been very, very slow and very frustrating for Australia's Indigenous peoples and our supporters. Nevertheless, what Commissioner Robinson touched on was that we, not just as the human rights institution in Australia, but people who are working on issues and elevating the voices through the framework of our rights, continue to do that. We continue to ensure people understand and assert their rights at all levels, and we continue to act in reminding governments, politicians, parliaments, and bureaucrats of our rights as Indigenous peoples, and demand that these rights be acknowledged in the framework of development of policies and processes, and our right, particularly in this piece of work with women and girls across the nation, our right to agency. So we're you know, continuing to voice our concerns in many spaces across this country through the leadership of Aboriginal and Torres Strait Islander men and women, and our supporters.
Yes, thank you. Thank you, Commissioner Oscar. Judge Reid, would you like to respond to that question?
Yes. First of all, I just want to add to the answer I gave for the previous question, which is just to say we're all assuming that recommendations that we make will lead to some structural change in New Zealand, and there is potential for change in Crown policy, change in legislative changes as well. So that all seems down the track at this point. But to get back to the question you've just asked, I mean, as you'll be aware, the government has here in New Zealand has pushed ahead with a consultation around how to implement the declaration in New Zealand, and really consultation on how to give Māori more autonomy, and have recently released a report which they appear to have been sitting on for a wee while. I think they're possibly quite nervous about it, called He Puapua. It has caused a bit of a stir. I think the media have really tried to sort of beat it up. But I think the general view is that Māori should lead own development and initiatives in health, justice, local government, and perhaps central government in terms of constitutional reform. And, you know, already the government has announced the establishment of an independent Māori health authority. And, you know, I have to say that that came, I think, at least in great part from a recommendation that came out of the Waitangi Tribunal health inquiry last year. So, you know, as I say, as I said in my comments earlier, we seem to be in a bit of a climate here at the moment where there is some willingness by the present government to discuss these matters. Whether or not it goes further than that is yet to be seen. We've also had change in the local government realm as well. Previously, there were referendums which were allowed if there were Māori members who were appointed to specific Māori seats for local government. That's now been abolished, and councils all around the country have now appointed Māori ward members to local government. So, you know, there are some hopeful signs, but you know, we're used to playing the long game, so we'll see where that all goes.
Yeah, I mean, you know, I think you're right, Judge. We have a climate where there's a readiness. I mean, certainly the Human Rights Commission, New Zealand Human Rights Commission, have been advocating continuously and very publicly for Indigenous rights commissioners. So in some ways, New Zealand, Australia, you're ahead of us because you've got June. We don't have an Indigenous commissioner, so but I think we have support. Now, unfortunately, we've run out of time for questions, and I just wanted, but before we move on, I just want to thank our esteemed panelists, Commissioners Robinson and Commissioner Oscar and Judge Reeves, for the very insightful and the very helpful and thought-provoking presentations. And I just want to acknowledge again Chief Commissioner Marie-Claude for your speech before we started really setting the scene and just shedding away any illusions about the reality faced by our Indigenous peoples, and especially our Indigenous women. So thank you everybody for your presentation, and thank you to our audience for the questions. I'll now hand it over to our Emeritus Professor, President Rosalind Croucher from the Australian Human Rights Commission, to wrap up our session. Over to you, Commissioner.
Thank you. Thank you, Commissioner Sonoa Mali, for your wonderful chairing of this evening. And I also thank all of our fine panelists for the discussion. Commissioner Landry and I are your bookends for the day, for the evening for me. And rather than thinking of it in that physical sense of bookends, I'd prefer to think of us as the both from settler backgrounds, but as arms embracing, embracing the voices of women, the speakers tonight, but also the voices that our speakers spoke about in speaking to their work, the powerful voices of the Indigenous women and girls that they gave voice to in their reports. And so much of what was spoken about is through the collective voices of Indigenous women and girls in each of our countries, in Canada, in New Zealand, and in Australia. And it's told from their first person and from lived experience. I want to thank all of the women and girls who participated in each of the inquiries and the work that is completed and ongoing. It's their voices, and we have the responsibility to carry their voices forward. Chief Commissioner Landry and the other panelists reminded us of our colonial pasts. I, like Marie-Claude, we have colonial history. For myself, my forebears come from Ireland, Scotland, and England. And I also bear in my hands the mark of the Vikings in the Viking knot that I have in my hands. I am one of 4 daughters, and I am the eldest of those 4 women, and I have a very powerful mother whom I miss very much. The work we spoke about expressed great pain, and a pain that continues in the present. But we also heard about power, of reclaiming space and place, and also of trust. We can't turn back the clock, but we can reset it for the future. In acknowledging country in each of our places, we recognise elders past, present, and emerging. And I want to finish my brief remarks with a focus on that future of the emerging leaders. And I also want to finish with the voice of an Indigenous woman. I want to share the last stanza of a poem that was shared with me by June's predecessor in title, so to speak, in the role of Aboriginal and Torres Strait Islander Social Justice Commissioner. And the poem is by poet Oodgeroo Nanakal. It's got a slight change in gender that I know June will recognise. And it goes like this. To our mothers' mothers, the pain, the sorrow. To our children's children, the glad tomorrow. So with that voice, the Indigenous voice, Indigenous woman's voice, I'd like to thank everybody that participated tonight and those who gave their questions, the staff of the Australian Human Rights Commission, of the New Zealand Commission, of the Canadian Commission for making it all possible to have this side event. So let's think on that about emerging leaders and our children's children, and let's hope that our work, the work of all the women who participated tonight, is part of that glad tomorrow. So thank you, everyone, and applause to all.